Hi, this is Richard Chamberlain. Welcome back to the Protecting Your Family's Future podcast. This is episode number 130. Today, we're going to be talking about questions that you need to be thinking about as you're getting ready to design your estate plan. We try to, when we're going to be meeting with clients, we try to give them a heads up about the kinds of things that they need to be thinking about in order to effectively design their estate plan to cover all of the issues that need to be covered. So, in this podcast today, I wanted to give you that same heads up. So, the first thing you need to be thinking about as you're designing your estate plan is what do you want the estate plan to do in terms of uh, avoiding probate, protecting your beneficiaries, because that is going to help point you in the right direction of the right estate planning tool, whether you use a will based estate plan or a trust based estate plan. We have plenty of episodes in the podcast that cover wills versus trusts. And if you're not familiar with those, I encourage you to go back and listen to those. That's going to be a fundamental question that you're going to need to answer. Your attorney can help you understand the issues and help guide you in the answer to that question, what's going to be better for you, a will or a trust. But you should have an idea really about what goals you're overall trying to accomplish in your estate plan. Now, getting into the actual design of the plan, there are several different kinds of things you need to decide. The first being who is going to be in charge of things if you can't be. So you're in charge of your own assets, you're in charge of your own health care, but if you become incapacitated, who would you want to manage those things for you? Who would be in charge of paying your bills or making decisions about uh, taking care of your assets or whatever needs to be taken care of, whether that's as the successor trustee of your trust or the agent under a power of attorney? And it's a good idea when you're talking about or you're thinking about how to set these things up, you have more than one person in mind as your successors, as your helpers in these situations. So if you're married, your spouse would usually be the first choice, but then you would have another person as a backup to your spouse and maybe someone else as a backup to that person so that you will always have somebody who is able and willing to serve whatever the circumstances may be. Now, if you're not married, you might have one person as a primary choice and then a backup. So that's going to hold true for all of these things. So, number one, who's going to manage your assets if you become incapacitated? Similarly, who's going to manage your assets when you pass away? Again, you want to have a couple of backup choices for that as well. Who's going to manage your health care for you if you're not able to do that yourself? So all of those people have different roles. The management of your assets while you're incapacitated, after you pass away, the management of your health care, and they're all three very important aspects of the plan. So make sure you've got a good idea about that going into that design meeting. The other aspect that you need to be thinking about, of course, is the distribution of your assets after you pass away. So you probably have an idea. Well, when I pass away, I want my assets, number one, to go to my spouse, if you're married. And if my spouse isn't living, then to our children. Maybe you have something else in mind. Maybe you want to include some charities. Maybe you want to include your grandchildren. It could be anything, but you should have an idea about the primary distribution of assets. Who should those people be or those entities be? What percentages should those uh, be distributed in? And you also want to be thinking about contingencies. So let's say you have the assets going to your children in equal shares. Well, what would happen if one of your children, for whatever reason, didn't survive you? What should happen with their share? Would it go to their children if they had children? Would it go to your other living children? Would it go to their spouses? A lot of different choices. You want to be thinking about that. And again, your attorney can help you decide what's going to be best for you, but having an idea about this ahead of time is always very helpful. Now, a lot of people will have their plan say, we want everything to go to our children. If our children aren't living, then to their children. So that would be what we call a per stirpes distribution to your descendants. You also need to be thinking about who your beneficiaries would be if you don't have any living descendants. In our office, we call that our remote contingent distribution. It's not very likely, but it is possible. So you should have an answer to that. That could be whoever your closest living relatives are. It could be specific individuals. It could be charities. But you want to have an idea about that that unlikely but possible scenario. So also, if you have minor children, you're going to want to know who the guardians would be for them, who you would want to be responsible for taking care of your minor children. So again, you should have at least one person and a backup for that. So as you are going into your appointment, it's helpful if you have an idea about these things. You don't need to have all of the answers. You don't need to have it set in stone. Because the best estate plans come from a back and forth discussion between you and your attorney who can guide you through how these things work, if you make this choice, this is what will happen, and this is why that's not a good idea or why that's a great idea. So they can help you with that, but you having an idea is always best. So take some time, think about these things, prepare for your appointment, and you will make the best estate plan for yourself and for your loved ones. So I hope that's helpful for you today, and we'll see you again next week. Thanks.